It's gonna look like we're gonna get this around, I don't know, shit, July of 2026, and it won't even be Yella Beezy trial. I think Yella Beezy actually gonna go to court, bro, in like October next year.
Okay, so there's a lot going on in this MO3 case. One, the fact that it happened 5 years ago, and bro, it's still nothing that really makes all the way sense yet. Clock in. Black Gotta just walked in. Team Black Gotta stand up, man. Yo. All right, y'all, we about to get into this video that you guys was asking for, man. Y'all wanted to follow up on the MO3 murder trial because I guess it was supposed to be today. And if y'all know some of the people involved in this MO3 murder trial is crazy big names. People like Yella Beezy.
New at 4 now, still no public sighting of North Texas rapper Yella Beezy after he bonded out of jail at 10 o'clock this morning. He's charged with capital murder in the 2020 death of Dallas rapper MO3. Prosecutors say Yella Beezy, whose real name is Marquise Conway, hired the hitman in that case.
So basically, Beezy bonded out. The court date was supposed to be today, but I guess it's not today, you feel me? And we're gonna see why in just a little bit. But I do want to go over a couple of things that happened at the bond reduced hearing. Like the fact that they played the video in the middle of the hearing to show how horrific the crime was that happened.
The offense, we do have evidence of when this could have taken place based off of cell phone data of when the defendant was in another state and then when he came back to Texas. So we believe we have a time frame. As far as the exact date, I do not have at this time.
Anything else, Mr. Joe?
No, Your Honor. Permission to publish, Your Honor.
Yes. You don't want the lights off?
It's at the court's discretion.
Oh.
And Your Honor, this is, just for context, this is approximately noon on I-35 heading northbound. This video is taken from a Kroger 18-wheeler, and this is heading north I-35 into downtown Dallas on noon on November 11, 2020. Now, Your Honor, if I could draw the court's attention, if you look on the, I've stopped this video at 19 seconds. You see a gold sedan in the far left lane and a black sedan in the second lane to the left. The gold sedan will be the vehicle carrying the victim, and the black sedan is the vehicle driven by Q1 White, who is then the shooter, based off of the evidence we have.
Okay.
All right, so them showing that was a way to show, everybody in the courtroom how horrific the crime was, and basically trying to prove to not only the courts but the judge this is why he deserves to have a $2 million bond. And if you know, 2 M's bond, yeah, that's a little hefty little price tag to get out, and state feel like it was a reasonable price due to the crime that took place.
Reduce this bond to an appropriate amount where he can abide by the conditions and come to court and we can fight this case.
Okay, thank you. State?
Yeah, sure. Just briefly. In regards to an individual's ability to pay the bond, Ms. Alexander testified specifically that she is not involved in her grandson's business and doesn't keep up with his financial stuff. So she really was not in a position to testify what he can and what he cannot afford. She did testify to the fact that he is a double platinum, I believe as of recently 2 weeks ago, recording artist, that he travels about a quarter of the month, that he lives in a mansion in Frisco, that he drives a Denali, a bulletproof Denali, which also will lead into safety concerns. So the only thing that the court has as far as ability to pay or not to do it, or not having an ability to pay this bond, is the bank records which I've proffered to the court, as well as his own grandmother saying that he's a successful artist living in a mansion up in Frisco that flies on private jets and travels. The important thing about the Denali is not just the fact of the cost and all of that, but it's the fact that when we're talking about safety concerns for the community, and one of the factors that the court should take into consideration is, if this individual were to get out, is there a viable safety concern? The fact that the defendant has a bulletproof vehicle and drove one at the time and was arrested in it 8 days ago, that should tell you all you need to know. And that's not just based off of pure jealousy. Your Honor has been doing this long enough to know that is based off of something much greater than just pure jealousy. As far as safety circumstances for the community, this is, as defense has stated, a very high profile case. And this defendant is very well known, not only locally, not only in the state, but nationally and internationally. The fact that this individual has the means and the resources and the reach to get to witnesses is a true concern that the court should also take into consideration. And that this was part of a bigger thing that was going on in 2016, 17, 18, 19, 20, culminating in the death of Melvin Noble. The circumstances surrounding her, not only the offense in itself, but the circumstances building up to Mr. Noble's death. And Your Honor, I didn't want to go back and forth with the defense on proffering cases of bonds and $2 million and $3 million bonds. But the truth is, this is a capital murder for remuneration. And the defendant is charged with paying other individuals to take another human life. And he has the financial means and the reach to do it. In fact, I think it's important that there was another victim. This was at noon on I-35 leading into downtown Dallas. 44 fired cartridge casings. Who knows how many others were knocked away by the cars that kept driving by. Melvin Noble was hunted down on November 11th in 2020, a beloved son of Dallas. It could have been so much worse, and that's a terrible thing to say when it's a capital murder for remuneration, where he has paid another man to hunt down and kill somebody in broad daylight. Your Honor, based off of all the testimony and the facts that have been presented in this court, we'd ask that you leave the bond where it is at, currently at $2 million.
So let me get this straight. You feel like he deserves to pay a $2 million bond. One, because he got pulled over in a bulletproof truck. Two, he's a recording platinum artist. And three, because you feel like he has the means to get the job done. My boy, that ain't gonna cut it. You know, it does sound necessary in some situations, but in this particular situation, my brother, you're gonna have to come a little bit more harder to believe he deserves to pay $2 million to get out when you have no evidence. The only evidence you have is he could have did it. Crazy work. Hearing that makes me fully agree with the judge's ultimate decision to push that thing down from $2 million to $750,000.
All right, let me have the exhibits, and then if you all will give me about 10 minutes, I'll respond.
Got it, Your Honor.
Yes. The defense did not have any exhibits, right?
No, Your Honor.
And this is just the video, right? That
Yes,
we've
sir.
already seen. Anything else that I need to take with me?
And you had 1 and 2 still.
Yeah, I still have.
Thank you.
All right. Okay, the court, is the court ready?
Yes, Judge.
All right, the court's ready to make my ruling. The court is going to reduce the bond to $750,000. The court took into consideration, certainly, the biggest consideration was the offense, the severity of this particular offense. It's pretty egregious to watch that video. But the court also took into consideration the evidence or lack of evidence that the state presented. That was a factor also. Another concern I had was the financial statement that the defendant was to put on file. He didn't seem to take that very seriously at all. And that causes me a concern about whether or not he's taking seriously the allegations against him. So I am going to set the bond at $750,000 with the bond conditions that were already set. But included on that, I want it to be very clear, Mr. Conway, that you are to have no contact, direct or indirect, no threatening or harassment of any victim, witness, co-defendant. If it's you or anybody on your behalf, there's going to be a problem. Do you understand that?
Yes, ma'am.
Okay, you all can stand. I'm talking to you now.
Yeah, totally agree, man. The evidence is not there at this moment, but what happened today can possibly, make their case stronger. And as y'all can see, they are pushing this MO3 trial thing back as far as could be, fam. Because, we pushing it back again. And I don't know the specifics on why it's being pushed back. But that boy Seti Nash opened up about the situation. And he originally thought that the trial was going to be today, too. But he read some information on them saying, nah, that joint got pushed back, famo.
Today I put out a video that basically said we was gonna get justice for MO3 today. Yeah, we about to take it to trial and see what was what and who's and all of that and everything like that. Well, Seti Nash kind of messed up on that one because there were some filings right underneath there, and I'm gonna clear it all up and then it's gonna make some sort of sense because it ain't gonna make no damn sense. Watch this. Yeah, I gotta sit back and eat this one. All right. So Dallas County is insane. I'm just gonna put that out there for y'all because basically when it came down to Devin Maurice Brown's freaking case at Dallas, what actually ended up happening was that this fool been getting his case pushed back like Stephen A's hairline. You feel me? So the first document that I showed y'all is October 17, 2025, and the court granted the defense's motion for continuance, meaning the trial was postponed to allow more preparation time. The next reset date was originally set for April 10, 2025 for a jury trial. But y'all understand that this was supposed to happen in damn April. So then by late 2025, another continuance was filed and approved, moving the pretrial hearing to January 9, 2026, and the jury trial to February 2nd, 2026. And then the judge basically has been saying, all right, we can do all of this stuff. So that's what y'all see it. And then these are the updates to show the defense and prosecution both agreed to push back trial multiple times. So Devin Brown's murder and related felony cases were initially scheduled for mid-2025, but after motions for continuances, were granted, the final confirmed trial date is February 2nd, 2025, with a pretrial hearing on January 9th, 2025. But y'all already know that's going to be a whole bunch of bullshit. Y'all know there's going to be a bunch of bullshit, right? Because based on everything in those filings, it's even more clear what's going on. Devin Maurice Brown's case basically is going to be pushed back again. Yeah, I know y'all like, nah, hell nah. So the court notes and the handwritten remarks on the form that I'm showing y'all right now tells you everything. It says continuation case is set, not ready. which is court shorthand for we're not ready to proceed yet. That means either the prosecution still has unfinished discovery or the defense hasn't received everything they need for the DA's office to send that over. So it basically means there's still unresolved issues tied to co-defendants like Yella Beezy and Kawan White, whose own legal motions are about to affect this because Yella Beezy has a goddamn case the same day. So we're going to host 2 murder trials on the same person the same day in different courtrooms. Yeah, I know. So while the docket list firm as goddamn January and February 2026 dates, the actual readiness of the case is still up in the air. And so I wrote this one down right here. Historically, Dallas County murder trials, especially multi-defendant ones, move slow as hell. The courtroom will post new trial dates and keep the case active, but that doesn't mean it's going to go to trial dead. Every time one side isn't prepared or another related case gets delayed, everything gets bumped back with it. The fact that the clerk's notes already mentioned not ready before the January pretrial even happens is a dead giveaway. They're bracing for another push. So, you already know, this shit about to get pushed back again. MO3 ain't gonna get no damn justice because I can damn near guarantee Yella Beezy's gonna get his stuff pushed back. It's gonna look like we're gonna get this around, I don't know, shit, July of 2026, and it won't even be Yella Beezy's trial. I think Yella Beezy actually gonna go to court, bro, in like October of next year.
Okay, so there's a lot going on in this MO3 case. One, the fact that it happened 5 years ago, and bro, it's still nothing that really makes all the way sense yet, man. At this point, I'm assuming that Devin Brown and Kewan Dontrell White are the main 2 people in this case, man. And it's kind of taking them quite a while to put Beezy in the mix. They will benefit from continuing to push it back because basically what they doing right now is playing a waiting game. They trying to wait and see if they can stack up some more evidence, see if anything could happen. Yeah, I know at the beginning of this video we seen the judge telling Beezy it's important not to tamper with witnesses. But to be honest, state is low-key sitting back hoping that they could get some sort of information like that. Cause the fact that it's taking this long shows me that, like, bro, they can't really put the nail in the coffin when it comes to all 3 people. You know, they got some time to work on it. They gonna continue trying to push it back because they either want somebody to tell, bro, or they want some more evidence to come out of nowhere. But hey, y'all let me know how y'all feel, if y'all feel differently, bro. But when I guess this case come back up, which it says February, I could kind of believe February will probably be the latest, bro. I'm pretty sure we'll get it in February. Said it feels different, but I'm pretty sure it'll start up in February. If it don't, oh yeah, the money looking funny.